two victories. One, the case is Our Lady of Guadalupe. This was an expansion of the ministerial exception for religious schools and institutions. What does that mean? It means the government is not going to allow courts and lawsuits to go digging into the decision-making process of religious institutions and churches when it comes to hiring and firing, specifically when hiring and firing is done based off the fact of someone's beliefs. The other case, one you have heard about time and time again for a decade, Little Sisters of the Poor finally getting the final victory that they have sought in court, and that was the codification of their exemption from the Affordable Care Act's mandate on contraceptions and abortifacients. They have now won in a victory there, 7-2. Let's start off with Our Lady of Guadalupe School.
The court, in its opinion, starts with the independence of religious institutions is matters of faith and doctrine is closely linked to the independence of what the court has termed matters of church government. So this tracks very closely to what we set forth in our arguments.
The last thing the government officials should do is to decide who is authorized to teach Catholicism to Catholics or Judaism to Jews, or in my case, Orthodoxy to the Orthodox. That is the business of the school and not of the government.
People want to talk about separation of church and state. Well, here it is. Keep the government out of churches and how they organize their institutions and how they choose to run them and who they choose to employ or who they choose to dismiss. That's one of the principles that's vindicated here.
Same makeup, by the way, in the case, the Little Sisters of the Poor, 7-2. Justice Thomas writing the opinion, Kagan and Breyer joining the conservatives.
Even when Obamacare was being debated on the floor of the House, this is one of the alarm bells that we raised, Jay, that if there was not statutory protections put in for religious entities, that this is exactly the path we would go down. Ultimately, Jay, Congress gave sort of a verbal assurance that the protections would be granted, and we said, look, the Obama administration is not going to carry those out in regulation, and that's exactly how it played out.
The ACLJ filed the first case challenging this mandate on behalf of a company in St. Louis, and we filed 7 others in federal court. And what the Supreme Court today essentially said was, we meant what we said in those cases. You cannot force these religious institutions and even secular employers with strong religious objections to do what their religion tells them they may not do. If you think that people need free access to contraception and abortifacients, then you, government, provide it. Don't make religious objectors violate their religious beliefs.
Look at how the court has given this broad autonomy to religious organizations. Both, one, to be exempt when they claim that something violates their conscience, and two, to have a special exception to even the civil rights laws in the United States on employment when it involves a ministerial exception, that they have these decision makings. Why do they get treated differently? Because the First Amendment to the Constitution decided, our founding fathers, when drafting that, said we are going to make sure that religious organizations is a higher burden.
There is a reason that religion was put in the First Amendment to the Constitution. That was the founding principle upon which the people who came from Europe to found this country were seeking to establish, and that should be untouchable by the civil government. And these decisions point to that.
The government does not get to tell a religious entity what is or is not central to its faith. So it could be singing, it could be chanting, it could be service to the poor, it could be teaching, it could be education. Jay, those decisions in determining what is central to your faith, those belong to the institutions, not to the government.
You've got this kind of supermajority of Supreme Court justices recognizing the importance of religious freedom and religious liberty, especially on these internal decisions, which is kind of the heart of religious liberty, actually.